Subscribe to our YouTube channel Shorthand Dictation Legal Matters, but never forget to hit on like icon and share with your friends. Thank you.
Ready? Start. The revenue being aggrieved by the decision of the board filed tax revision petition before the High Court under Section 86, Subclause 2 of the Act. The High Court dismissed the revision petition filed by the revenue and upheld the decision of the board by holding that the respondent unit is a prestigious unit and therefore entitled to 75% tax exemptions under the scheme. Aggrieved by the order so passed by the High Court, the revenue is before us in this appeal. We have heard learned counsel for the parties to the case and perused the documents on record as well as the order passed by the authorities and the High Court respectively. The learned senior counsel appearing for the appellant submits that the case pleaded by respondent unit right from the beginning of filing the application before the state level screening committee was that the new unit had made an investment of more than 500 crores by way of fixed capital assets and therefore they should be placed under the category of prestigious unit and accordingly be granted eligibility certificate to claim 75% of exemption from tax for the maximum time limit provided under the scheme. In aid of this submission, the learned senior counsel would draw our attention to the application and the accompanying affidavit filed by the respondent unit before the state level screening committee. He would further contend that the respondent unit before all the authorities below, including the High Court, had adopted the stand that the fixed capital investment excluding investment made before 5th March 1997 was more than rupees 530 crores and therefore the respondent unit is a prestigious unit entitled to an exemption of 75% of total tax liability. It is further contended that the respondent new unit being new cement unit and further being large scale unit though can avail the benefit of the incentive scheme under 1E of Annexure C which provides for exemption up to 25% of total liabilities. It cannot avail the benefit of exemption at the rate of 75% under item 4 as prestigious unit. He would further submit that benefit to cement industry is confined to the extent envisaged under the item 1E of Annexure C as the said item is a specific provision relating to cement industry. Alternatively, it is contended that the respondent unit being new cement unit, it may fall under new very prestigious unit. However, item 5 of Annexure C speaks of the new very prestigious units other than cement units except those located in subplan area. Respondent unit may not be entitled to avail the benefit of the scheme. Per contra, learned counsel would justify the reasoning and the conclusion reached by the High Court while rejecting the revenue's revision petition and thereby confirming the view expressed by the board. He would inter alia submit that item 1E is only an exception to the general rule envisaged in item 1 and not an exception to the general rule envisaged in item 1 and not an exception to the other items in the Annexure C, that is items 2 to 7, as it is not intended to govern the entire field of exemptions made available to the cement industry so as to deny the benefits to a unit even if it falls under another item envisaging better incentives. Stop.